Yeah, so good morning, everyone, or good afternoon where you are. I see a number of familiar names in the attendees list, so hi to you all. And then what I'm going to want to talk about today is focus very much on this notion of military objectives, and then using it in the context of counterspace operations. So Jeremy, if I'm just going to shout every time I want you to move on, so rather than go with please, etc. So forgive me for that. So yeah, here we go. So this is what I want to talk about today, and I've been given about 40 minutes, which has a bit of flex here and there, and I very much encourage questions. From what may seem some of the most basic questions are the most difficult in this area. So very much encourage questions, very much encourage challenge. So the overview, gonna give a bit of understanding of military objective, historically, contextually. Then going to have to deal with a precursor question, which is what is an attack? And I'll explain why that's a necessary precursor question. And then there's various things you can look at when you dig down into trying to apply the term military objective in operations. And I'm going to focus specifically on these four words: nature, location, purpose, or use, all of which you'll find in the test of military objective. Slide. So Jeremy gave a kind of general disclaimer. This is my personal disclaimer. So what I'm about to say is very, very much the view of no one else. It certainly doesn't necessarily reflect that of the Royal Air Force, the UK military, defence, the UK government. What I'll also say here actually is at times I've knowing my audience, I've particularly looked to what the DoD Law of War Manual says on some of these issues. And I do disagree with the interpretation that's taken the DoD Law of War Manual, but please accept that I have a huge amount of respect for what's in that publication. It's an exceptional publication, but I disagree with it at times, and we'll get into that in the future. Slide. So starting with an overview of military objective. Slide. So when we talk about military objective in a kind of colloquial military sense, we could say, okay, we want some Marines to go take a bridge. You know, that in some senses that's a military objective, but the term military objective by conflict has a very specific meaning, and it's a relatively recent terms in terms of actually having a fleshed out definition. So historically, if you look at the Brussels Declaration in the 1870s and the Hague Regulation in the early 1900s, what was targetable, what you could attack, was focused on this bifurcation between defended and undefended localities. So if an area was defended, you could attack it, and if it was undefended, you weren't entitled to. And the rationale for that was it's very land focused rationale, and basically if your army can take a location because it's undefended, there's no need to attack it. So that was the kind of paradigm at the beginning of that period of time. If you look at Hague Convention 9, you see the start of an evolution in how we think about what things should be targeted in warfare, because although Article 1 of Hague Convention 9 talked about this undefended, defended locality issue, Article 2 also said that there are certain objects that, irrespective of whether a place is defended or not, that naval bombardment is entitled to go and attack. Why is that important? Why do I mention it? That's because it was the start of this idea that the kind of function, the benefit in attacking something should dictate what's a military objective or not. So then the Hague Rules of Air Warfare were drafted in the 1920s, and Article 24 introduced this concept of military objective really for the first time. But those draft articles were never became a treaty. It's controversial to what extent any of those provisions reflect customary international law then and now, but it's significant because it introduced this concept. And it was generally accepted, although the definition itself wasn't necessarily accepted, it was generally accepted that prior to World War II, that aircraft could only target objectives, even if we don't necessarily agree on what that term means. And then the Geneva Conventions has this term military objectives. The Geneva Conventions are 1949, so post-World War II. They have this term military objectives in a number of places, but again, not defined. And so we're left with this kind of difficult position where we think about what can we target. We think about things like military necessity, but we don't have an agreed upon definition. And that's seen as being a fairly major drawback with the state of the law of armed conflict at that time. Slide. So Article 52 of AP1, having been negotiated at the diplomatic conference that led to Additional Protocol 1 to the Geneva Conventions, they with this definition. And I'll get into why this is of interest to the United States and other states that are not party to AP1 because it's customary. But if we test is, skipping forward a little bit, this test is pretty much accepted as customary international law. So the key things to focus on, and we'll dig into this in a bit more detail later on, are those things in different colours or in bold. So it's generally recognised to be a two-part test. You have to think about whether there's an effective contribution to your enemy's military action. And then if so, if you can destroy it and it offers you a definite military advantage, then it's a military objective. So a definite military advantage to you, and it effectively contributes to your enemy's military action. That, in a nutshell, is the test. Slide. So the obvious question in a presentation about space is why is this? First of all, is this customary? And second, if it's customary, does that extend to counterspace operations? So it's almost universally recognised that test of military objective in Article 52.2 is customary international law. AP1 only applies to international armed conflicts, but you see multiple decisions of international tribunals, you see military manuals of various states, you see state positions of, for example, of Israel, who aren't a party to AP1, all except that 52.2 is customary, certainly in land warfare. And then in the maritime context, San Remo manual adopted Article 52 as customary in naval warfare, and it's generally accepted as customary. Now, does that extend to counterspace operations? Well, when I talk about counterspace operations, I include the targeting of ground stations, etc. So clearly that's applicable both as a matter of treaty law and custom. And then extending it into outer space, the DoD manual takes the position that you apply treaties and customary law to space as you would any other domain. That gives rise to a few issues that I won't bother getting into here. But essentially, you could take the position that, well, we don't have any state practice. You know, this hasn't been warfare in space to date. However, that's a kind of misunderstanding of customary international law, in my view. If the state practice, consistent state practice, that one must distinguish between military objectives and civilian objects, and there's no reason to think that the opinio juris attendant to that was meant to restrict its application to just the Earth. I think we're on pretty safe ground that the test of military objective in Article 52.2 applies to operations in space as well as they do on the ground. Slide. Okay, so having dealt with why everyone on this presentation is interested in the text of Article 52.2 in the context of counterspace operations, I'm going to deal with a precursor question of attacks. Slide. So why in a presentation about military objectives am I talking about attacks? Well, the reason is set forth in Article 52.2, and it says that attacks shall be limited strictly to military objectives. So the practical import of this is that something short of an attack doesn't have to be restricted to military objectives. So, for example, for a long time, including World War II, PSYOPs or psychological operations have been directed against civilians. That is permissible under law because that type of activity is not an attack. So what is an attack is the dividing line between having to distinguish between military objectives and civilian objectives. So that's why it's such an important concept in LOAC, and has to be distinguished between armed attack in Article 51 of the UN Charter, different body of law, different test. So if attacks is the kind of necessary predicate to thinking about what's a military objective, then what is an attack? So Article 49(1) of AP1 essentially boils down to an attack being an act of violence. And that's generally accepted as the nutshell of what is an attack. The problem this gives rise to is how people conceived of violence when Article 49(1) was being drafted. So obviously bullets flying, tanks firing, aircraft dropping bombs, these are clearly violent acts. But the evolution of cyber operations has been kind of main focus of looking at attacks in a different light. If we apply that to space operations, the example of giving there is jamming of, for example, over a large urban area, the downlink of GPS and the effect that could potentially have on the civilian population. That doesn't sound like a violent act, but should it be considered an act of violence, and therefore triggering the need to distinguish and other rules from that. Another example, in space itself, now you can functionally deny the capability of a satellite without having to blow it up. So for example, if one were to be able to use remote access tools to position the sensor satellite away from what it's supposed to be looking at, so and turn it towards either the sun or just make it functional, then you've denied this expensive kit that might be relied on by militaries, but you haven't, is that a violent act? So how people have looked at this as both states and experts in academia, they're focused not so much on this word act, but it's more about violent consequences. So if I can reasonably expect that my military does something and it will a destructive effect or injure someone or kill someone, and it's foreseeable, and flows through, so it doesn't have to be immediate, the foreseeable consequences included, then we can think about that as an attack. There is a strong degree of debate as to where the dividing line is. And the US position in particular is an interesting one, because if you look at the DoD Law Manual and you look at pronounced by the State Department, the US position is you look at factors. So one of the only factor actually listed in the DoD Law Manual is on reversible temporary effects. So that is something you have to factor in deciding whether something is an attack or not. Interestingly, it says reversible effects. It doesn't say reversible act. So if you were to, in interpreting the DoD Law Manual, if the effect is not reversible or temporary, then that's what you have to look at, not whether the actual, for example, jamming is inherently reversible, but if that it could have potentially might not be. But I think in most cases, things like jamming will not amount to an attack. And when it does, it is not clear in international law at the moment. And ideally, there would be some kind of resolution in a treaty, but I don't think that's forthcoming in the near future. And just to clarify, these positions that are taken in the cyber context have to be read across to space, because first of all, the relationship between space and cyberspace is so intimate. And second, logically, there's no reason to say that those statements by states such as the US, by France, by Israel recently, no reason to restrict them to cyber only. So what is attack? That is when you have to start thinking about what's the military objective. Slide. Okay, so having dealt with that, what I want to do is look at these words: nature, location, purpose, and use, and flesh out some of the issues that come from that when you apply it to counter-space operations. Slide. So focusing first on nature, the kind of two questions that are pertinent here that I want people to think about. First of all, what objects are military objectives by nature? And most importantly, what are the consequences if we do classify something as that, because there's disagreement on the consequences of saying something is a military objective by nature. Slide. So essentially there are two main positions. One is that if an object is military by nature, that's all you really need to think about, i.e., yes, there is this sort of second limb in Article 52.2 that talks about there needs to be a definite military advantage as well as effective contribution to military action. But something that is by nature military must, by definition, automatically amount to a military objective, and therefore we don't have to go for the stations of the cross, as it were. And then the second approach is, well, actually the whole point of Article 52 was to always think of the circumstances ruling at the time. And circumstances ruling at the time is stated in Article 52 textually. Therefore, you can't automatically say something is a military objective, even if it, by its nature you would think of it as such. And then applying that sort of dichotomy to space, I think the best way to think of it is a dead satellite. So you can have a military satellite, something that has been launched by the military, has been operated by the military, owned by the military, used by the military. So we're pretty comfortable that it's a military objective by nature. That satellite is no longer functioning. If you take the automatic approach to its logical extreme, that dead satellite remains a military objective by nature. Potentially even if it's been put into a graveyard orbit. But too much could be made of this. In most cases, the gap between these two positions is just, I thought about it for a nanosecond and yes, it's a military objective. So for example, a direct ascent anti-satellite weapon is a very good example of something that would be a military objective by nature. For those who think, you also have to think about whether the offers you a definite military advantage. Clearly destroying or disabling another state's anti-satellite weapon offers you a definite military advantage, unless of course you don't have any satellites. So the position taken in the DoD Law of War Manual is that certain objects will all be considered to be military objectives. And these are the two sort of categories of objects that are always considered to be military objectives. So objectives belonging to the armed forces and used in military operations, and then objects containing military objectives. So we'll get into some of that in the next few slides. Interestingly, in terms of objects containing military objectives, certainly if you had a factory that was containing or a place of assembly of military satellites, I would consider that a military objective. I do the Law of War Manual goes too far though with this objects containing military objectives because, for example, combatants using a house as a bed down location at night and changing up where that bed down location is, that would be a military objective, yes, but temporarily used. I don't think it's a military objective by nature, more by use. And then looking at the different positions, comparing the DoD Law of War Manual, the UK and English manuals take a different position. Doesn't spell it out as well as the DoD Law of War Manual what the position is, but essentially seems to be that you always have to think of the circumstances at the time, and you can't automatically say something is a military objective by nature. Slide. So interestingly, the ICRC commentary, which is used to interpret provisions in targeting law, when it looks at military objective by nature, it says that these kind of objects are all objects directly used by the armed forces. So I take issue with this. To me, it doesn't make sense to tie whether an object is being used to the nature criterion because its use is already dealt with elsewhere in Article 52.2. So a more general point, when you read people talking about LTWRC, they often refer to the ICRC commentaries or authoritative. Now, the literal meaning of authoritative means it's a reliable source, and I would caution that although it's influential and it's a very useful source, there are often parts that it would conflict with, for example, the Law of War Manual or other interpretations of LOAC. So it's a good source, but I think to describe authoritative, it goes too far. So if we think that use is the wrong way to think about nature, which I think is correct, how to flesh it out with an example. So Hawkeye 360 is a commercial satellite suite of satellites that use synthetic aperture radar, as if I recall correctly. And I've seen things in open source that say that US combatant commands have used some of the products produced by Hawkeye 360. If directly used by the military means something is by nature a military objective, then that seems to include things like Hawkeye 360 satellites, which were produced to supply commercial and military consumers, as it were. And also, this issue of directly is unhelpful, as we see in other contexts in LOAC. So the ability to target civilians when they directly participate in hostilities. There's a lot of controversy over what's direct participation and what's indirect. So I don't think tying anything to directly is particularly helpful. So having pointed that out, there's clearly a suite of objects that are very obviously military objectives by nature. So warships, tanks, fighter aircraft, heavy machine guns, direct ascent anti-satellite weapons, the Soviet produced co-orbital ASATs that were tested in the 70s, for example. These are all things I think we can easily say are military objectives by nature. And if you take the DoD position, you'd have to think about whether it offers you different military advantage. You can just attack it. But often people just talk about military objectives by nature and say, well, you know, military, that is used to sort of add military and then move on. There's some issues with that in terms of the space context, because what makes something a military objective if we're saying military equals military objective by nature? So, for example, GPS was designed for military use, but has come to be relied on by civilians. So, is something being designed for military, does that mean it's military objective by nature? And if so, does it have to be only designed for the military? Often people talk about things like own operated. That is problematic if that's supposed to, it should be the underlying condition. And I use the example of Skynet. So UK's major military communications capability is delivered through Skynet constellation. At present, that constellation is owned and operated by the commercial sector. So the UK uses that light for its military operations, but it's not actually flown or owned by the military or the UK government. And then if we think about, well, perhaps something is military by nature if it's exclusively and permanently controlled by the military. I think that has some benefits, but then again, it's not necessarily the most clear criteria, because what do we mean by control in that context? And control has different meanings in different areas of international. Slide. When thinking about a military objective by nature, often people talk about actually an object class. So you don't look necessarily at the object per se, you look at whether that object falls into a category of sort of objects that you would think are military objective by nature. So the most obvious example being anti-satellite weapons. You know, I can't use my anti-satellite weapon as a toothpick. I can't use it for pretty much anything other than for military purposes. So it's intrinsically military. Communication satellite as a class of object is not intrinsically military, because most communication satellites are used to enable television consumption and view. So if we look by object class, then that would point against things like communication satellites being military objectives by nature. Again, that's only one way to look at it potentially. So having discussed military objectives by nature, there are different ways to look at it and different ideas of what the consequences are for determining something is a military objective by nature. And then thinking also ahead a bit to the future, if we're going to increasingly move towards automation in military systems and targeting systems, then how we consider something to be objective by nature, particularly if we're saying the consequences of that are that we can target it automatically, that has major implications for lethal weapon systems. So with that, we'll move to the next slide, thanks. Okay, so having talked about nature and sort of raised a few questions there, we'll move on to location slide. So I think the location criterion in Article 52 gives rise to really interesting issues in counter space operations, and we obviously talk about things in outer space. So I think there are two main issues. You can get into the zone question into here. So the two main issues are objects in space be determined to be military objectives by their location, and then can specific areas in space be considered to be military objectives, and therefore can they be neutralized in accordance with Article 52.2. Slide. So Article 52.2, what do I mean? If you look at Article 52.2, it says that an object by its nature, location, purpose, or use can be military objective. Therefore, an ordinary provision would mean that something by its location alone is military objective. And when we apply that to objects, it gives rise to some quite interesting questions. Now, the DoD makes clear that objects can, by location, be military objectives. Often people think about it as being a specific area, but it can be just an object itself based on its location. And here's the example the DoD law manual uses. It says that during military operations in urban areas, a house can be located, provides cover to enemy forces, or would provide a vantage point from which attacks could be launched or directed. That could be a military object by location. Slide. Now, I disagree with the DoD Law War Manual position. And the reason I disagree is because although the location criteria was added was the one that was added later on in the negotiation in Article 52.2, and it wasn't clear exactly why states did so. I think there's a general agreement that the location criterion shouldn't be read too broadly. I've got Dinstein there because, being someone who normally interprets SLOAC in a relatively permissive way, I always take particular notice when he cautions against something. And that position taken in the DoD Law War Manual, if you, for example, were to conduct urban operations in Seoul, which has over 1,500 high-story buildings, it would basically say that any of those buildings could be destroyed based on the fact that they offer a good vantage point for field of fire, for example. And then using that thinking and applying it to space, well objects in space sometimes are considered, to provide military based on the high ground that they provide. Not a perfect analogy, but you can see what people are getting at. I think it's pretty problematic to say that objects in space can be targeted based on their location. And the reason I say that is because, first of all, there's a difficulty with what's a definite military advantage, and it has to be perceptible rather than hypothetical and speculative. But more fundamentally, if we think about this, people do not argue, and people have argued this point about space and location and allowing targeting on that basis. When the San Remo manual was being produced, there was a general acceptance that the location criteria would be pretty much irrelevant in a naval context because of the ability of objects on the water or under the water to navigate and they're mobile. And again, we don't hear people advocate or argue that aircraft are military objectives based on their location, 10,000 feet above the battle space. They probably are military objectives on other criteria, but certainly not on the location basis. Slide. So I'm very skeptical of the location argument that some people make about it, of location. The location of an object in space makes it a military objective. The ordinary meaning, which is one of the first things we should think about when interpreting a treaty provision. When we're thinking the ordinary meaning of location, that's the Oxford English Dictionary definition, a particular place or position. Well, anything in orbit is in perpetual motion and moving at a very fast pace. And although something in orbit has a predictable pattern of maneuver, things can maneuver between orbits. And I think the location criteria is an ill fit for space objects. And the reason I say generally in this slide is because I do think there's a decent argument that a spacecraft was inadvertently positioned so that it was interfering with your ability to use your satellite, i.e. too close and interfering with the electromagnetic spectrum you're relying on. I think there's an argument there that because of the location of that other satellite, you might be able to target it. But other than that sort of specific example, I'm pretty skeptical. And then finally, this location criteria could be in future. We've had recent announcements about lunar bases, so I wouldn't exclude it from that context, but probably more likely if something were to be military objective there, it would be via use or purpose. Next slide. We talked about whether object can be a military objective by location. The second question is, can a specific area be denied? So that's definitely the case. Multiple states, including my own, when it signed up to AP1, said that an area of land can be a military objective, and therefore, if states were to use mines, for example, to deny an area of land, or to use harassing fire to deny soldiers on the ground to sort of access a bridge, if they weren't able to deny the bridge itself, there are examples of an area that can be a military objective by location. And the DoD manual as set out there also clarifies an area of land can be military important and therefore a military objective. So how do we apply this, or can we apply this to counter space operations, particularly operations in outer space? So I put that ICRC quote because I think this is a fair assessment that that has to be limited areas, and it's focused around passages, bridgeheads, and strategic points, mountain passes. Whenever people talk about this, that's really what they're getting at. Next slide. And when we're thinking of space, being able to try and divide it into specific areas is quite difficult, pretty much impossible. I think the closest one can get to is to think about things like a satellite in geostationary orbit, because of its unique kind of trace compared to Earth. It sits there in a stationary position, essentially. That perhaps is the closest one can get to a specific place in space, and that could be relevant in terms of area denial. But how do you deny an area, even if you read Article 52 in that way? Again, I'm a little bit skeptical. So slide again. So sea time's moving on, so I'll try and be fairly quick with these last two. So use is a relatively simple one in many respects. So use refers to the present function of an object. And I think I saw Elizabeth Waldrop on the attendees list, and she's written an interesting piece on the integration of military and civilian satellites. And that's a sort of a bullet point to demonstrate the amount of reliance on commercial satellites. So commercial satellites, if they're used for military ends, they're very likely to be a military objective. But you can't just think use, tick, that's enough. You have to think about whether there's an effective contribution to military action and a definite military advantage. Slide. Now, an effective contribution. If you look at the negotiating history to AP1, when the ICRC introduced draft treaty, they had the word substantial contribution. that didn't survive the negotiating history. So there doesn't have to be, the use doesn't have to give rise to a substantial advantage. And that's a quote from the Harvard Manual on Air and Missile Warfare. And I agree with that, that the term effective basically means it contributes to military action. There isn't this kind of high threshold for what that means. And I'll skip over the economic targets thing. We don't have time for that. Next slide. Next slide. So finally, before we introduce purpose, this is a really important one for any context, but particularly military space operations. And the reason I say that is because often when you hear people talk about space capabilities, they talk about dual use, and what they're driving at is that not really dual use, but dual purpose. Something that has no military benefit at one point in time can very quickly be spun up and used by militaries. And therefore, this purpose criterion is really important. So the DoD manual, when it interprets purpose, it has this interesting definition. It says, the purpose of an object means its intended or possible use in the future. So I 100% agree with the intended use, and the possible use, I think, stretches things too far. Next slide. I'll give you a second. This is a quote from a Michael Schmidt article, just to read that. So I think possible use goes too far, because anything in space could potentially be used for military ends. In fact, anything in any domain can potentially be used for military ends. If you take that to its literal conclusion. I'm not sure the DoD manual meant it to go that far anyway, but it can be read that way. So I would caution. This does rise to really interesting issues in terms of how reliable does intelligence have to be? Can we make reasonable inferences based on previous behavior? So, for example, if you thought that which the Chinese space industry is overseen by the PLA or other elements, to what extent does that give you a head start in saying satellites that are flagged, although satellites aren't flagged, but satellites that are ostensibly of a particular nation can be reasonably said to will be used in intended future use by a state. Some really interesting questions, some practical questions there. And with that, given the time, I'll shut up and see what questions we have. Thanks.
All right, thank you so much, Kieran. Really, really appreciate that presentation. A lot of wonderful information. We're starting to get a few questions in. The first is from Michael Schmidt, and what Michael Schmidt would like to discuss. Moving back into your nature section, he asks about, what about combining your criteria with respect to what makes something military, right? So particularly, something could be designed for exclusive and permanent use by the military, but then, like you said, with GPS, perhaps it has civilian functions as well. So Mr. Schmidt asks, shouldn't it matter who is operating, specifically getting at whether that's an issue of direct participation along with the status of the facilities used by the civilian entity? So can you speak to that question of combining your criteria for the nature of what makes something a military object?
Yeah, so I think that's a potential avenue to try and get a more bright line test of what is a military objective by nature. Because part of what I did there was play devil's advocate and saying, well, that sounds like a good idea, but hang on, if you apply specific criteria, then that, what about this type of satellite or type of satellite system? So I think combining some of those could be a good avenue for providing more guidance. But the thing is, I don't, I've read, and Professor Smith has written on a lot in this area, and other people talk about military objective by nature, but often you don't get a kind of definitive position based on these kind of criteria. And I think it's an area where often you can get there via use or purpose, but I do think that's practical significance. And I think for us, it's suggested and potentially combining criteria to get to a solution is one that's worth taking. I'm currently writing this section of my PhD, and I haven't come to a firm conclusion yet on what the best criteria would be. But I think a combination of things could be a solution.
All right, wonderful, thank you. We have another question that has come in from Major Jeff Coleman of the United States Air Force over at McConnell Air Force Base. Major Coleman asks, most, if not all of the countries that you referenced kind of over the course of your presentation are Western or Israeli. Where does China stand on the definition of military objective? Does it tend to be more or less broad than the international consensus?
Yeah, so interesting question. So taking a step back, I've seen a statement by a Chinese government official at a UN forum saying that LOAC applies to outer space. So that's the kind of the precursor question. In terms of military objective, it's signed up to AP1, so it has to use that in a land context. Also, from a treaty perspective, Article 49(3) actually says that if something may affect civilians on land, then the treaty provision will apply, and that gives rise to some interesting treaty and provision interpretations. I think some counter-space operators in space could, as a matter of treaty law, bind, for example, China. But in terms of its view on customary international law, actually, often when you see Chinese scholars talk about LOAC and space, they definitely agree that principles of LOAC have to apply, like military necessity and distinction and things like that. They don't necessarily always say that this tested military objective does. But I think it's logically pretty difficult to get away from that, and I certainly haven't seen anyone flat out deny it.
Kieran, I just have a question. How would you expect? Obviously, you've been talking about targeting military objectives in outer space. The distinction between things like acts of violence and what that means in the context of certain space objects. Could I just get your thoughts as to the possible response of a state that owns a space object to the extent that an attack, quote unquote, on a space object perhaps wasn't a true physical act of violence in the sense of destruction or a kinetic attack? What would you typically see from a state party who owned that space object as an appropriate response to maybe a cyber attack or a jamming of an uplink, those sorts of attacks that you talked about that perhaps are not physical acts of violence?
Yeah, thanks. So in terms of the attack question, by definition, when we talk about attacks, there is an armed conflict already in place. And the idea of the definition of attack is to give states an understanding of what they have to distinguish between, basically. So if I'm conducting a military operation that's not an attack, I'd have to worry about whether it's a military objective or not. So the question of sort of what a state's response would be, I think, is more relevant to an armed attack or a use of force against a satellite, for example. So at the stage at which we're sort of the initial salvo, there's in terms of how a state responds to an attack in space, if it's an attack and as long as it's a military objective, the state that is subject to it certainly can't complain about it, and neither can the international community. Of course, when I've spoken about attacks here, I kind of use the shorthand for being it's a legitimate target, but always when you're thinking about this, it's, is it a military objective? Yes, it's a legitimate target, but I also have to then think about precautions in attack. And I also have to think about the proportionality rule And in space, actually, when you talk about debris, the indiscriminate attack rule becomes more than it typically is on ops, because that rule is generally in conventional context is dealt with when you're doing weapons reviews, and is less relevant when you're sort of advising at the tactical or operational level. But in space, with the effects that can spread from debris, it's a question that needs addressing at least.
Awesome, thank you. We've gotten another question into the chat, again from Michael Schmidt. He asks, to what extent is the work being done on attacks in cyberspace either influencing or complicating the application of the notion of attack in outer space?
Well, it's certainly highly influential, because if states have given any kind of opinion on what is an attack, it's always been in a cyber context, because that was the trigger because until cyber came along, people weren't really thinking about this question of what is an attack. If there was any debate, it was normally to sort of just cover off that we meant defensive and offensive force, just defensive force and things like that. So it is the coming of the cyber age which has given rise to the question, which actually gives rise to some pretty difficult questions too, because the ability to jam, so deny someone's capability through denial of spectrum, etc. That's been around for a very long time. That's predated the cyber age, and jamming was going on in World War II. And going on in conflicts post World War II, prior to the cyber age. And the ICRC in its 2015 challenges report actually says that jamming is something that typically hasn't been seen as being an attack. Now, as cyber has sort of pushed the question of what is an attack, and there's been a sort of growing consensus that we look to the consequences of an act. So if the consequences are at least give rise to physical destruction, even if not denial of functionality, that is an attack. But then how does that rub up against sort of the history of being able to jam things and that not being an attack? Now, in most cases, jamming something is not going to give rise to violent consequences, so it becomes a moot point. But you can see certain circumstances where sustained jamming or minor functionality could flow through to sort of civilian harm, and that's kind of where the debate is. Certainly it's all taking place in the cyber context, and maybe we as states advisors should be making the case that this isn't a unique, because often you see people write about it saying it's unique to cyber. Well, it's not unique to cyber, because the denial of the function of an object has been something that's been capable for a long time.
All right, great. A couple more questions in the Q&A first. And you may have discussed this a little bit to the extent of discussing things like space debris and whatnot in reference to the question that I asked you. But we have an anonymous question. In considering whether an act amounts to an attack under LOAC, to what extent do you think indirect / second order effects must be taken into account?
So I think you have to take into account secondary effects, because when you're in a cyber context or in a space context, if you're looking to deny a state's ability to use an object, it's always the consequences on civilians that LOAC is interested in. And to say that sort of any secondary consequences you don't need to be concerned about goes too far. The difficulty is how far do you have to go? Because if, say, for example, I were to say, well, you have to think about what's reasonably foreseeable. Now, if I buy a lottery ticket, it's reasonably foreseeable that I win the lottery. But I've got a 1 in, 100 million chance, more likely to be struck by lightning. But you could say that's reasonably foreseeable. At the same time, if I go at something and deny its functionality, and I'm very confident that it's going to have a negative effect on civilians. So, for example, GPS in my country, there's been reports saying that underpins basically everything that you would kind of call under the category of critical national infrastructure. It dictates where ambulances go. So if you were to provide GPS in a sort of a large sort of urban area, or where there's a big population centre, you can reasonably foresee that there'll be a negative impact on civilians. But that's really difficult to map, and that's really difficult to know in advance. So it gives rise to really difficult questions for the military. If I was going to have to boil this down to an operator, I'd say, do you expect this operation to result in damage or death? And if so, it's an attack, and we have to think about military objective precautions and proportionality. But it does give rise to some really difficult questions, and that's I'm not part of the US system, but this factors approach it's taken to attacks demonstrates that it's a difficult question, and it's one that's still evolving. And the Thailand manual, which Professor Smith is obviously the editor of, it's been highly influential in sort of having these different nature of consequences, approaches, and what that means for an attack.
Awesome, thank you. Question from Stuart A. Although to some extent he believes that perhaps his question was to some degree answered with your response to Mr. Schmidt's question related to cyberspace. But Stuart A. asks, to what extent do you envisage states will set out their interpretation of how IHL applies to counterspace operations, aside from military manuals, projects such as Woomera, Millamos, etc.? This is asked in the hope that state practice doesn't develop. Is it going to be a case of relying on developments in the cyber domain? How is that all going to work?
Yeah, so there's a few things there. I guess I can see from some perspectives why there would be a reticence to talk about it, but that is, to me, to misunderstand the whole purpose of LOAC. To talk about LOAC applying to space doesn't mean that anyone wants space to become a place where hundreds of satellites get attacked, etc. The whole purpose of LOAC is to provide a reasonable modicum of protection to civilians, etc., whether directly or indirectly, to link back to what we just talked about, in the event that war happens, because war does happen. The UN Charter tried to prohibit war, but war is a fact. So I think there's an unnecessary taboo at times about talking about this kind of topic. Then to answer the question, do I think states will set out the position? I think so. I mean, for example, the DD Law War Manual's got a really interesting section on applying LOAC to cyber. The space section doesn't really get into that. It just says that it applies, and that's it. I mean, I would anticipate it to be an update that it would tackle it, but I guess there could be some sensitivities around it. I would hope so, because thinking about how it would apply in advance is to help those who are going to, if it unfortunately were to occur, would help those who would then have to advise on real time. So doing the kind of heavy lifting in advance is what it's about. It doesn't necessarily mean anything more than that.
All right, great. I don't see any further questions in either the Q&A box or the panelist chat box. As Squadron Leader Tinkler, do you have any final thoughts, parting words before we close this off?
Just to say to thank you again for giving me the invitation. Thanks to Mike for originally putting me in contact with you. If anyone does have any questions or thoughts, particularly having had a quick look through the attendee list and seeing some pretty good names down there, if anyone wants to chat to me about any of this, I'm obviously really interested in it and I'd be happy to talk further.